This is the final session of today, and we're going to address issues related to the international settlement of disputes. My name is Liesbeth Lijnzaad. I'm announced as the legal advisor of the Netherlands, which is true, but I would like to make the point that I'm here in my personal capacity or perhaps in my academic capacity, so nothing I say is on account of the Netherlands government. By way of introduction, I would say we have excellent panelists to talk to us about international dispute settlement. On my right-hand side, and the first speaker in this session is Professor Nathalie Klein of Macquarie Law School, and she's also the Dean of the Law Faculty there. She has published extensively on issues related to the law of the sea and has a wealth of knowledge in that field, particularly related to dispute settlement as well as to security questions. So we're happy to have her speak and be the first presenter. On my left-hand side, we have His Excellency, Mr. Arif Havas Ugroseno, am I right? I'm sorry, sir. Who is the Deputy Minister for Maritime Affairs of the Republic of Indonesia. And with him we have, I think, someone who is a great practitioner of the law of the sea, and that implies we have an academic looking at things from perhaps a more academic perspective, and a practitioner looking from a practical perspective, which is perhaps not necessarily the same as the academic perspective. Both of them are, in general terms, from the region, although I do believe Indonesia is nearer to the South China Sea than Australia is. Looking at the matter of the international settlement of disputes, if you look at Article 33 of the UN Charter, it provides you basically a whole list of suggested methods to settle your disputes in a peaceful way. Now, it is interesting because it looks like you have quite a series of methods to choose from. So what does that mean? And then if you look at the UN Convention on the Law of the Sea, that not only contains a fairly extensive system for the settlement of disputes concerning law of the sea issues, in part 15 together with annexes 6 until 6, 7 and 8, which leads to a fairly detailed system, and a question could be whether that is a closed system or whether other options are also possible. Now, in preparing for this afternoon session, it dawned on me that we also have Annex 5, which deals with conciliation, and I can't remember having heard a discussion about Annex 5, and maybe that is something that ought to be addressed as well. Of course, early 2013, the Philippines took a remarkable step to take the matter of their dispute with China to arbitration. We have heard that China is not in agreement with that step taken by the Philippines, and that they do not formally participate in that arbitration. So that leads to quite a lot of interesting questions with respect to how does this dispute settlement system under UNCLOS function? Is one obliged to participate? Would it be better to participate, or could you easily stay outside if you wish to? And also perhaps an underlying question, what is a dispute precisely about? Is it about delimitation? Is it about sovereignty? I think in the previous session we have heard a number of elements that add up to feed into that debate. So without further ado, I'd like to give the floor to Professor Klein for her introduction on the limitations of UNCLOS Part 15 dispute settlement. Thank you.
Good afternoon. It's my pleasure to be here to be able to speak on these particular issues, and especially given that in looking at the South China Seas, this is an international law perspective, to have an opportunity to think about how some of our dispute settlement methods available under international law might be applicable to this very difficult and challenging region. Before I begin, I do want to just thank the organisers for the kind invitation to be able to come. It's been a really fascinating day so far, and I feel like in looking at dispute settlement, it is an opportunity to try and bring together some of the issues that we've looked at. In my presentation and thinking about the international law dimensions, I will focus on the dispute settlement regime that's available under UNCLOS and that's set out in Part 15 of that convention. I will give a short introduction to that. I'm imagining that nearly everyone here is probably well familiar with that, but I do want to draw out some of the key points of that dispute settlement regime and what it means in trying to resolve disputes relating to the South China Seas under UNCLOS. And then I'm going to focus quite specifically on the Philippines and China arbitration and provide some background to that, and look specifically at challenges to jurisdiction and what are the potential limitations to how the UNCLOS dispute settlement regime may operate. So looking at the obligation to negotiate and what effect that might have, and the contentious matter of the subject matter jurisdiction. I want to focus on these two particular points because I think in the first instance they go to the very heart of how the dispute settlement regime operates. And certainly in looking at subject matter jurisdiction, it really goes to how we understand maritime space and what maritime entitlements actually mean. And with subject to the time constraints, I'll hopefully have a few minutes to think about what might be some of the consequences of the case, both for the states involved, for the region, and for UNCLOS dispute settlement more broadly. So just by way of background to the UNCLOS dispute settlement regime, there were just a few points here I wanted to highlight. And that is particularly that when we're dealing with this very important multilateral treaty, it's important to recall that any state that is a party to this treaty consents at the time that they become a party to this treaty that some disputes can be referred to compulsory procedures entailing binding decisions, or arbitration or adjudication, and that there is no separate consent necessary for this. It is enough that the state is a party to the treaty. So it's significant that there is mandatory arbitration or adjudication. But we also have to bear in mind that it's quite a flexible regime. And in one of the ways it's quite flexible is that it is still quite deferential for states to be able to determine in their own right what forms of dispute settlement they might choose to follow for various law of the sea disputes. And it might be the case that some of those dispute settlement methods may prevail over the procedures available under UNCLOS. It's also important to bear in mind that the UNCLOS dispute settlement regime is not comprehensive. So not every single dispute relating to ocean affairs can necessarily be resolved under the UNCLOS dispute settlement regime. There are important limitations built into the convention, as well as states being given the option to exclude certain disputes from the scope of the dispute settlement regime as well, notably maritime boundary delimitation cases that might concern military activities and certain law enforcement activities. Now, bearing all of this in mind, when we turn to the Philippines and China arbitration, we've already heard a little bit about it today. And so, as you're aware, the Philippines instituted proceedings against China at the start of 2013, and in doing so appointed an arbitrator for these proceedings. Now, in the 30 days that China had to appoint its own arbitrator, what China instead decided to do was to return to sender the statement of claim and notification that China had received, and returned the documents and said that there was no jurisdiction over this dispute and refused to participate. Now, even though China has refused to participate, there is rules that allow for the appointment of arbitrators. So the President of the International Tribunal for the Law of the Sea could continue with the appointment of arbitrators. And certainly, even if China does not participate in the arbitration, that case can still proceed, and it falls to the arbitrators to ensure that there is jurisdiction and that any claims are well-founded as a matter of law and fact. You know, it was interesting, Professor Franks commented this morning and raised the question about why it was we were having this discussion about the South China Seas here in Belgium. And I had actually wondered that myself when I was first invited to the conference. But when I thought about this arbitration, I thought, well, of course, because 4 of the 5 judges that have been appointed are European. So suddenly Europe has a very important role to play in this region. So it seems very timely indeed that we should be here and considering these questions in the heart of Europe. Now, in terms of the claims that have been presented in this particular case, so far we only have the statement of claims and notification from the Philippines. A memorial has been filed. I've heard it's 4,000 pages long, but it's not publicly available at the present time. From the statement of claim which was released, I think we can probably categorise the Philippines' claims into 3 different categories. First and most importantly, there is a challenge to what we've been hearing referred to as the U-shaped line or the 9-dashed line or the 9-dotted line. I tend to call it the 9-dash line. I guess we all have our personal preferences around that. So the Philippines has challenged that the 9-dash line is not consistent with UNCLOS. Then in another category of claims, the Philippines has pointed to a number of different maritime features, we can call them. These are our islands, the rocks, the islets, the low tide elevations, and has stated that even if we do not know the ownership of these particular maritime features, we can still clarify what these particular features are and what their maritime entitlements might be. Then a third group of claims relates to a challenge to activities that are happening around these islands, and particularly challenges to the exploitation of resources and the fact that China has been exploiting these resources and preventing the Philippines from doing so. Now, the Philippines has presented a series of declarations it is seeking from the tribunal, as well as a number of orders. And amongst these orders, the Philippines is seeking orders that China must end its unlawful occupation of certain features, that it must adjust its domestic law to align with obligations under UNCLOS, to cease interference with Philippine vessels, and to desist from undertaking activities in relation to different maritime features. Now, although China has refused to participate in the arbitration, shortly before it would have normally been due to present its pleadings, China instead issued a position paper from its Ministry of Foreign Affairs. And in its position paper, it comes out and more strongly describes why it is denying jurisdiction. And for China, it argues strongly that it is essentially a case concerning territorial sovereignty. And the Philippines has acknowledged that disputes relating to territorial sovereignty do not fall within the UNCLOS dispute settlement regime. And China says, well, this case is entirely about territorial sovereignty. And if it's not, then it implicates maritime boundary disputes. And maritime boundary disputes have been excluded by virtue of Article 298. This is one of the exceptions to the compulsory dispute settlement regime. In addition to that, China has also argued that the Philippines has failed in its obligation to negotiate, and that there is a binding obligation on the Philippines to negotiate to resolve differences relating to the South China Sea, and that effectively this precludes them from being able to resort to arbitration. So, if we start with this last argument first, what about this obligation to negotiate? To my mind, it's quite clear that within the UNCLOS dispute settlement regime, that states have an option as to how they are going to resolve disputes, so long as they do so peacefully. Article 280 makes clear that, that states are able to agree at any time to settle a dispute between them concerning the interpretation or application of this convention by any peaceful means of their own choice. So what China has argued is that there are a series of joint statements that have been issued between China and the Philippines, as well as the 2002 Declaration of Conduct between China and the member states of ASEAN, that set out a requirement that any disputes that arise should be settled by negotiations and consultations. So China is of the view that these agreements actually constitute a binding legal obligation. I think there is a live question as to whether these particular statements by the parties are really political undertakings, or whether they had intended to go so far as to create a legal obligation. In my view, I had not actually seen that the 2002 Declaration of Conduct or the joint statements really did amount to more than a political undertaking, beyond the fact that some of those statements recognise existing customary international law obligations or existing treaty law. But apart from that, there wasn't any intention to create any new obligations, and particularly not a new obligation to negotiate. So this will be a question for the tribunal to decide. But I think probably the more interesting question that needs to be resolved is that if there is an obligation to negotiate, does that then prevent the Philippines from pursuing arbitration under UNCLOS? Now, the key provision that we need to look at here is Article 281 of the Convention. And in the Southern Bluefin tuna case, an arbitral tribunal decided that it did not have jurisdiction because the parties in that instance did have an alternative means of dispute settlement that they had agreed to. Now, for China to rely on Article 281, China will have to show that not only that no settlement has been reached, but also that the alternative procedure, namely the obligation to negotiate and consult, excludes any further procedure. I think it probably is fair to say that if there is a binding obligation to negotiate in relation to particular law of the sea disputes, then it follows from the Southern Bluefin tuna decision that Article 281 will apply, and therefore there would not be jurisdiction in this particular case. I think we have to draw a fairly clear line, though, in terms of what that obligation to negotiate looks like. It has to be an obligation to negotiate, I think, within a treaty, in a formal legal agreement, that this is the preferred dispute settlement method for this particular law of the sea dispute. Because there still exists a right, if you like, if not an obligation, for states to continue to negotiate all the time to try and resolve their disputes. States do negotiate even when cases are in arbitration or adjudication, because sometimes they settle their disputes before a final decision is reached. And so we should still anticipate that that right to negotiate, if not an obligation to continue to try and resolve a dispute, exists, and that that particular right shouldn't necessarily preclude the operation of Section 2 of Part 15, being the compulsory procedures. So it might be difficult to find the balance between the two, but I think it is necessary. Also tied into the obligation to negotiate is a requirement to exchange views, which is set out in Article 283. And the Philippines set out in its statement of claim how it had exchanged views in relation to the different claims for the various island features. And there's a fairly low threshold that has to be met for exchanging views under Article 283. And so long as the UNCLOS claims were referenced at some point, then I think it's fairly easy to meet that particular threshold. The bigger question around the obligation to negotiate is really whether that obligation will preclude resort to compulsory procedures by virtue of Article 281. So I think that really goes to the heart of how we see this dispute settlement regime working, because there was a lot of objections to the Southern Bluefin tuna arbitration about the fact that it had cut down Part 15, but I was in a minority of thinking it was a good decision. Perhaps I will be in a minority again. If we turn to subject matter jurisdiction, the initial point that we have to determine is whether this is really a dispute concerning the interpretation or application of UNCLOS. That's what's in Article 288, and China takes issue that this is really a territorial sovereignty dispute. So it is vital to characterise a dispute so as to know whether it falls within the scope of jurisdiction or not. I find that the arguments of the Philippines that focuses on particular marine features and says that we can look at these marine features and determine their status without needing to know territorial sovereignty runs against the fundamental nature of maritime space. We've long operated on the principle that the land dominates the sea, and the International Court of Justice has recognised this proposition on a variety of occasions. It may be said in, I think, perhaps a facile way that the consequence of the land dominating the sea is that all we have to show is that there is some land. And once we know there's land, then there's sea that attaches to it, and that could just end there. But if we're taking into account that land comes with particular maritime entitlements, then I think we have to ask, what are the maritime entitlements? The entitlements are sovereignty, or their sovereign rights to the marine resources, or their jurisdiction over activities occurring in the designated marine areas. These are the rights that are enshrined in Article 2 of UNCLOS, which establishes the territorial sea, and Article 56 that establishes the rights under the exclusive economic zone. And we also have to recall the status of the continental shelf, which exists ipso facto and ab initio from the coastal state. That maritime entitlements accrue to a state is an inexorable consequence of the nature of that entitlement. Indeed, each of the maritime entitlements in question are explicitly tied to a state. And these are the entitlements of a state, a political entity, not just a physical landmass. If we take the language of Article 2 of UNCLOS, that provides the sovereignty of a coastal state extends beyond its land territory and internal waters, and in the case of an archipelagic state, its archipelagic waters, to an adjacent belt of sea described as the territorial sea. This provision clearly anticipates that sovereignty, as the maritime entitlement of a particular landmass, is that belonging to the coastal state. The contiguous zone is inherently linked to a coastal state, as well as the powers granted to the coastal state therein reference a zone contiguous to its territorial sea. It's a zone to be measured from the same baselines that you use to draw the territorial sea, and the entitlement to such a zone permits a coastal state to prevent or punish certain acts that happen in that maritime area. Article 55 defines the exclusive economic zone as an area adjacent to the territorial sea, and in which the coastal state and other states have specified rights and obligations. So it is the coastal state that has sovereign rights and jurisdiction in accordance with Article 56. Hence, the entitlements are directly linked to ownership of the land by a state. The definition of the continental shelf immediately identifies the continental shelf of a coastal state. So what is the point of an entitlement if we don't know who is entitled? The Philippines would have us focus on Article 121 and Article 13. Article 121, as we know, relating to islands, Article 13 on low tide elevations. But I don't think that we can separate these particular provisions from the particular entitlements that we're talking about. It seems to me that it would be quite odd to suggest that a rock can be so classified or a low tide elevation identified, and they're thereby deemed to be a landmass giving rise to sovereignty over maritime space, without knowing which political entity is entitled to that sovereignty. So I would suggest that it is imperative for any court or tribunal in deciding whether it has jurisdiction under Article 288 not to examine provisions like Article 121.3 or Article 13 in isolation, but to recall that these provisions are very much tied into a larger schemata that divides maritime space into various zones as measured from terrestrial features, and accords rights and obligations to states by virtue of that state's ownership of the relevant landmass. And it's that landmass that generates these different maritime zones. So when we recognise these linkages, it's evident that the undetermined sovereignty is a critical issue, and that maritime entitlements cannot or should not be articulated when there is uncertainty as to which state those entitlements accrue. So when the interpretations are placed in their complete contextual setting, I would suggest the central dispute cannot be seen as one uniquely relating to the interpretation or application of UNCLOS. And similarly, if we look at some of the exceptions in Section 3 of Part 15, I think we run into some of the same problems. So China has excluded maritime boundary disputes, and it is argued that we're not looking at a maritime boundary delimitation dispute. We're not challenging the particular provisions such as Articles 74 and 83 relating to delimitation. But entitlements are an integral part of this process. The first thing we need to know for delimitation is, are there states that have overlapping coasts that are adjacent or opposite to each other? What is the land area, what is the maritime area that needs to be delimited? We have to be able to define the area that is going to be delimited, and we can only do that when we know the ownership of the land generating the maritime zones to be divided. So in this respect, it also makes it very difficult to assess the lawfulness of activities that are occurring, the exploitation of resources in this area, without knowing who actually owns the particular areas, without actually dividing up these areas. I tell all of my students in the law of the sea that the first question we always have to ask is, where is something happening? We need to know where it happens to be able to know what rights and obligations follow. And we can't know for sure where some things are happening here. So I think there probably is a basis for saying that these issues are too closely linked to a maritime boundary delimitation to fall within jurisdiction. It seems that there might be an additional problem in another exception under Section 3, which relates to law enforcement activities. If China is preventing the Philippine vessels from fishing, this could be construed as a law enforcement activity that also falls outside compulsory procedures. And I think there may also need to be questions asked about the scope of military activities, since military activities can also be excluded from compulsory procedures. Here it's difficult because we don't really know the exact parameters of what constitutes military activities. The Philippines has made claims about China unlawfully occupying various areas. So is an illegal occupation a military activity? If a state is forcefully asserting their rights as they see them, does that count as a military activity, or is it going to be a law enforcement activity? We need to tease these particular issues out, but it certainly makes it a more complicated issue in trying to determine whether jurisdiction exists or not. So turning to the other core category of claims that the Philippines has raised, and this relates to the 9-dash line. And this is a very complicated one because we've already heard today there's some question about what this 9-dash line actually means. So we're not sure what its purpose or its status really is. It could be an ambit claim to sovereignty over all the islands in that area. So if it really is just this territorial sovereignty claim, then it's a territorial sovereignty dispute and doesn't fall within UNCLOS. But what if it's a unilateral delimitation by China? We know from the Anglo-Norwegian fisheries case that every unilateral delimitation still entails an international aspect, and therefore we can examine this. If the 9-dash line is dependent on ownership of the islands and other maritime features, then we're still probably in that difficult area about this being a maritime boundary delimitation case, or potentially still about the sovereignty. But if it is just a line that China is purported to draw from its mainland coast, or it's said to reflect historic rights, then I think there probably is a basis to look at that as a question of interpretation or application under UNCLOS. Is it consistent with drawing an exclusive economic zone? Is it consistent with drawing a territorial sea? Is there a basis for claiming historic rights that extend that far from the mainland? So on this analysis, it would appear that what might be the single most controversial aspect of China's claims in the South China Sea is one that might be the most likely subject to jurisdiction of the arbitral tribunal, in my view. In the few minutes remaining, let me just bullet point some of the consequences of the decision. Of course, it's hard to be able to say what the consequences will be when I can't be sure what the actual decision itself will be. But I think we do have to note that it's important that the Philippines has brought this case consistent with one of the original goals of establishing a compulsory dispute settlement regime, which it was there for less powerful states to be able to try and protect their rights against assertions by more powerful states. And so it's really important that this avenue exists for a state to be able to use. I think it is significant that in doing so, that the Philippines has triggered a reaction from China in its position paper to actually defend itself as a matter of international law. And it's shown that international law is very much part of the dialogue in the South China Seas. It might not be the decisive factor in how some of these disputes play out in the end, but it does have an important role to play. So within the South China Sea, it's also important to note that any holding on the validity of the 9-dash line will obviously have consequences for the other claimant states as well as some of the neighbouring states as well. And certainly Vietnam, I should mention, has put in a statement, as we've heard today, to the arbitral tribunal to try and protect its views in the case as well. And it remains the possibility that Vietnam may well institute proceedings against China. Just finally, it's also significant about what this case might mean for unclose dispute settlement in the future. If we do actually get a decision which allows for, that recognises jurisdiction and goes ahead to resolve a particular case looking at Article 121 or Article 13, even though there is this contested territorial sovereignty dispute, does this then mean that other disputes involving contested territorial sovereignty might start getting scooped within the unclose dispute settlement regime? So not too far away from the South China Sea, for example, I'm sure Japan and South Korea are watching this case very carefully because of their dispute over the small island or rock known as Dokdo in South Korea, Takashima in Japan, and South Korea presently occupies Dokdo. Both states are parties to UNCLOS. South Korea has similar exceptions to China. Japan hasn't made any exceptions under Article 298. But surely if the tribunal goes ahead and decides on this case, it does send a message that maybe other of these sorts of disputes can be resolved. So I think there is a very important precedent that is going to be set by this particular arbitration, both in relation to how the unclose dispute settlement regime operates and also for the region as a whole. I would expect that the arbitral tribunal will make a very careful decision given the high political stakes as well, but obviously time will tell on that particular one, so we'll see. But thank you for your attention.
Thank you very much. Thank you very much for that extensive overview. That was very useful. And I'd now like to pass the floor to His Excellency, Mr. Arif Havas Ugroseno. I hope I pronounced it correctly this time. Sir, you have the floor.
Thank you very much, Professor. Let me begin by thanking Professor Franks and VUB to invite me for this event today. It is not unusual, actually, because the last time I was involved in bringing the European Union to sponsor a workshop on the South China Sea in Indonesia, I think 2013, if I got it right, because I believe the linkage between the European Union and Asia, East Asia and Southeast Asia is so strong that I think we have the same interest in maintaining peace and security in that region as well. So I think it is something that's commendable, and I think it should be done more often, actually, to have these kind of discussions here in Europe. I will give a presentation on two parts. I think the first one is the context. It's important to understand the context these days. And then the second one on the possible scenarios of the settlement disputes on South China Sea. I recall Professor Ted mentioned about the ups and downs of the conflict in South China Sea Sometimes it's very noisy, sometimes it's calm. But I think it's also important to look at the fact that there are different strategic environments of today and 40 years ago when this thing started initially. I have a couple of points, I think 6 strategic environments that is dramatically different today and 40 years ago. First and most important is that ASEAN itself has matured. ASEAN has morphed itself into a rule-based organization. ASEAN is an organization based on rules. It has its charter in 2009. And many countries, including China, has acceded to the fundamental treaty of ASEAN, the Treaty of Amity and Cooperation of 2010. So I think in general, the relations between ASEAN and China have been largely positive and developed into a much more structured engagement at the head of states level. ASEAN itself has now a very extensive maritime cooperations. I helped establish back in 2010 an ASEAN Maritime Forum. It was coming from a discussion with some colleague in the ASEAN circle. Then we finally pushed forward the idea to have an ASEAN Maritime Forum. It has 11 areas of cooperations. It may not necessarily be related to South China Sea, but in other areas of cooperations, I believe the ASEAN Maritime Forum has been very useful. They have been meeting, the last meeting I think was in Vietnam, and there are a number of projects together that we do within this context. And we have also move into an element today of what we call the ASEAN connectivity. So the ASEAN connectivity and ASEAN Maritime Forum are very much linked within the ASEAN as well as beyond ASEAN. The second one is the fact that ASEAN has been very instrumental in providing a security architecture in our regions. You like it or not, in East Asia and Southeast Asia, you have now 2 security infrastructures. The first one is the American-led infrastructures. American-led meaning America, Japan, Korea, America, United States, New Zealand. You still have these very strong treaty relationships between the United States and those countries. So you have this US-led security infrastructure. The second one is the ASEAN-led security infrastructure. You have the ASEAN 10 plus now the ASEAN Defense Ministers meeting, ASEAN Defense Ministers plus the US plus China, Japan, Korea, and China. And also India come of late. So I think we have a new security architectures there. We are increasingly witnessing the Chinese-led security infrastructure in the region. So this would be a specific subject of workshop, I think. It will be very interesting to see how this will evolve future. The third one is the socio-economic conditions of Southeast Asia and East Asia. I mean, it has changed tremendously. 4 countries of this region are member of G20, and the GDP of ASEAN combined is $2.3 trillion. It's larger than India. It's almost twice as Russia. So it's a different economic dynamics in the regions coming up these days. And the number 4 is the threat assessment. 40 years ago, the threat assessments came from the regional wars among nations, ideological wars among nations. But today, the threats are different. They require lots of regional collaborations. Terrorism, one issue. Pandemics, the trafficking of persons, organized crimes, drugs, gun running. These are the new threats that they don't exist 40 years ago. And this requires countries in the regions to actually work together, and I think becomes a catalyst in many of these dispute that could have flare up even further. The number 5 element, I think, is the culture of international law. I mean, we have been having a discussion among international law professors in the region, and some people said that, well, you know, we're not like the Europeans. We have less culture of international law in East Asia and Southeast Asia. It could be true, it could be not true. If you look at Indonesia, for instance, we have about 15 to 16 maritime boundary treaties that we have. We have settled our dispute with Malaysia in the ICJ. Malaysia and Singapore settled disputes on the Peter Branca Batu Puteh also in ICJ. Malaysia and Singapore settled disputes on reclamations in ITLOS. So we have this practice of international law culture coming in. I think the case of arbitration of the Philippines, I agree with Professor that also add, you know, to the development in the regions of the respecting of more of international law. So we also have a very interesting developments in terms of the private practice of international law in Singapore. Has become now one of the center of the regions on the private practice of private international law. Now, the last strategic environment, I think, is the Chinese program of the Maritime Silk Road, the 21st Century Maritime Silk Road, which I believe if it needs to become acceptable and successful, then it has to work together with countries in the region. And also Indonesia itself, we have just launched a new maritime policy, which is comprehensive and invites infrastructure investment, invites a number of cooperations with the global countries. So these are these different strategic environment that evolves today that I think has become some sort of buffer, and that I would imagine would not turn the South China Sea into a flashpoint. I mean, people are talking about flashpoint in a rather casual way, but I think if you look at the definition of flashpoint, what is flashpoint is all about, it will never become a flashpoint. The Middle East is flashpoint. Europe could be a flashpoint. You've seen what happened in the eastern part. I think it's flashpoint. Not in South China Sea. Now, the second part, I think, about the sovereignty dispute. As I mentioned before about the case that we have brought to the ICJ, and what Professor just mentioned about the different ways of settlement of dispute. Well, there have been some confusion, I think, in the media, even in the government circles in the region and also beyond, that somehow UNCLOS is the legal framework to settle the dispute. This is some comment I've seen, the media as well, political statement as well. So I think this needs to be clarified. The basic issue in South China Sea is overlapping claims of islands and rocks and islet and whatnot. But I think that is the most important element. Now, international law, customary international law is the basis to settle those disputes. We have taken the disputes with Malaysia, Siparan Ligitan and ICJ, small islands, same thing. Malaysia and Singapore has also brought the same issue on ownerships of rocks, Peter Branca, Batu Puteh to the ICJ. The delimitations comes later. So I think this is the first fundamental issue that needs to be understood, that the sovereignty dispute must be taken under the principle of customary international law. Now, our case with Malaysia, it's pretty straightforward, you know, 2 islands and a little bit of rocks here and there, and 2 countries. But in the case of South China Sea, you have 5 state claimants, and you have one which is not exactly state, Taiwan, and you have over 100 features. Some of them are subject to claim, some of them are not, some of them are islands, big islands, some of them are small islands. So it's, I would say personally, it's impossible. It's a problem that it's difficult to solve if you really want to bring it to a third-party adjudication. But I think the most important thing is the fact that all the claimants are legally obliged to settle the dispute in peaceful way, in peaceful manner. I think this is the most important fundamental fact that we have to keep saying, especially at the political declaration at the highest level and all different levels, that we need to underline continuously that however difficult the question is in South China Sea, all the claimants are legally obliged to settle the dispute in peaceful manner. Now, we have in the UN Charter on the obligation to settle dispute in peaceful manner, but you also have in the Treaty of Amity and Cooperation of ASEAN. DOC is not legally binding, but the Treaty of Amity and Cooperation is legally binding upon ASEAN countries as well as China, who has acceded to DAC. So under the treaty, it's very clear that you have to settle this in peaceful manner, or at least manage this in a peaceful manner. Now, of course, earlier on, Madam Chair, you mentioned about Article 33 and the different options of settling the issue, arbitration or judicial settlements, negotiations, inquiry, mediations, conciliations, and regional agencies or arrangements. So actually this one element that so far has not been engaged fully. I think this is an element that would be very interesting to see down the road, whether or not all the claimant state is willing to see the possibility of having regional agency or arrangement with ASEAN. They all party to the TAC. They are legally obliged, legally bound to settle the dispute in peaceful manner. So this would be one of the things that they could consider in the future. Now, this morning we heard about the position of China, which basically said that let's shelve the sovereignty dispute and develop a joint development. This is one of the things that's been going on, which, we like it or not, probably that is, for the time being, could be the most realistic way. Because if you are looking at the number of the claimants, if you are looking at the number of the islands claims, so it's something that it's a little bit difficult if you want to really settle the problem. We cannot settle the maritime delimitations without settling who owns what in the regions, and nobody seems to be willing to go, to the ICJ or to any other mechanisms, unless you want to actually take a strong political decisions to go into adjudication or the regional arrangement that I have just mentioned. If you are trying to look at the crystal ball, probably the current status quo in terms of geostrategic, geopolitical, it should be so far okay with occasional flares here and there, but it should be maintained, not to go into the higher level of conflict that would be on the geostrategic elements. People would say, there are two opinions actually. One opinion would normally say that, well, why don't you try to settle this issue through any means? But if you look at other practice, even in European Union, you have Gibraltar case. Two members of European Union is a very highly regionalized, highly integrated region in the world. Yet you are not able to settle that issue since a couple of time. So it's emotional issue, always national sovereignty. It's something that is not easy to settle. So that would be the state of the situations today. We are now at the government level working on the code of conduct. There are some positive development which we cannot divulge yet, but they are very slow development. But I think the fact that they are there, they are sitting, and they are evolving. What Professor Ted have done with Ambassador Jalal, it's amazing, because this code of conduct, the declarations are all the what we call the side effect, the consequences of the second track that you have worked in the informal setting. So I would like to close there. We are still a long way, I think, personally, from actually settling the issue, unless the claimant states are willing to go into a creative mode of solutions. Thank you very much.
Thank you very much. So we have had two very interesting presentations, and no doubt there are questions in the room. And may I also invite people in the back rows, because it has occurred to me that the questions all came from the center, but feel free in the back row to also raise your hand if you want to raise a question. Yes, sir, you on the left-hand side.
Thank you, Madam Chair, and many thanks to the panelists for exciting speech. My name is Moto Maeda from law firm Three Crowns, and my question has been prompted by the last slide of Professor Klein. You mentioned the involvement of more than many states in this region, and assuming that the subject matter jurisdiction issue is overcome, and there is probably a big if here, how does the existing interest in more than two states, i.e. multiple states, affect the admissibility of this case, or possibly the arbitral tribunal's ability to judge various issues on the merits? I have the mandatory gold principle in mind, but I will leave the question open so that you can probably broaden this issue. Thank you.
Thank you. I'll see if there are some more questions. Yes, sir. Yes, I gave the floor to you, and then somebody reminded me of the other people, but
yes,
I will get to
I was very interested. You kept referring to land. Previously, we've been hearing about islets as the safe term, and then islands and land forms. But I was wondering how that term relates to the definition of island, and wanted to point out that most people outside of international law, and I understand there's very specific provisions for what an island is, but for instance, flat island would be a Philippine island, and it's got vegetation, and it's obviously been above water for a long time because there's an ancient Chinese field temple in the middle of it. And the island occupied by Taiwan, Ituabu or Taiping, is 1.2 kilometers across. It has altitude of up to about 5 feet, and it has over 100 species of terrestrial plant. And I believe Spratly Island itself, which is a Vietnamese holding far to the south, is also a very substantial piece of land. So that's 3 countries that have things that are, you know, most people would think would be land, and I'm not sure if that would fit your definition of land, and if it did, what would that, how that would play into your assessment of the Philippine claim.
Thank you. I'll take a question at the back, and I'll get to the left-hand side in a minute. Yes, you, sir, please.
Thank you. Masa Ishii, I'm Ambassador of Japan to Belgium. I have 2 questions to Professor Klein. Of course, we are following the Philippine-China case, as you mentioned, with a lot of interest. And from that viewpoint, 2 questions. Number 1, you talked about the obligation to negotiate. And we don't have to continue to negotiate at the expense of the obligatory procedures. I agree with you. But to me, it's a bit too much if you just in the middle of a serious negotiation, you just decide to go to the arbitration saying that let's do it parallelly. So in my mind, you need to clear two criteria. Number one, you make, at least you need to make reasonable efforts to come to the conclusions of the negotiation, and it's not fulfilled. And number two, you have to give enough notice to the opposite side. And only after that, you can go to the arbitrary procedures. How does it sound to you? Second question is about the delimitation. Delimitation is obviously out of the reach of the compulsory procedures. But you know, when there's a conflict over delimitation, there's also an obligation written in UNCLOS saying that you refrain from doing something that change the status quo. So what if we argue that what the opposite side is doing is against that obligation, but this is not the issue of the delimitation? How does it sound? Do you think that can fall within the jurisdiction of the arbitration? Maybe, sorry, last quick question to Arif. I'm sure you discussed this in the boarding. This is fishery agreement. I mean, does it sound reasonable to ask you to start negotiation of multilateral fishery agreement among all the claimants in South China Sea? My point is, you know, number one, that is normally the cause of the conflict. I mean, conflicts over fishermen. Number two, you can conclude fishery agreement without completely solving the issue of delimitation. Thank you.
Thank you, and I'll turn to the panelists for replies and ask both of them to be brief so we can do a final round of questions. Sir, maybe can I turn to you first?
Thank you, Prof. Yeah, you're right, Ambassador. It's not only, you don't need to have a maritime boundaries to have a fishery agreements. We have a very stark example in Indonesia. We have CTI, Coral Reef Triangle Initiative. It's an initiative to protect coral reef in the area of Indonesia, the Philippines, East Timor, Solomon Islands, and Papua New Guinea. We don't have maritime boundaries with them, but we can do that. Inland, we have Heart of Borneo. It's arrangements for conservations between Indonesia, Malaysia, and Brunei. So it's something that is doable, something that is actually been discussed between the parties. Thank you.
Thank you for all the questions, all good points to consider. In relation to the impact on other states, strictly speaking, of course, any decision of the arbitral tribunal is only binding on those states before it. So I guess I'm a little more realistic that once you have a holding by a particular tribunal, even if it's technically only binding on other parties, it necessarily has implications beyond that. In terms of, you know, can this decision still go ahead, or the monetary gold principle might be implicated? I think because of the way that the monetary gold principle was interpreted in the case concerning East Timor about, you know, there has to be that predetermination of one state's responsibility before determining another state's responsibility. I don't think we have that particular setting here. So I wouldn't be concerned in that regard. Where I think there is still a lot of difficulty is that we only have one state participating in this arbitration, and so to the extent that some of the findings requires information from China, that is going to make it difficult, and whether that information can come from other sources, to the extent the arbitral tribunal will go outside and look for those, that information, it makes it a difficult process, especially when that threshold is to make sure that any holdings are well founded in fact and law. So when I'm saying that, I'm thinking about the 9-dash line argument, and to be able to get to the point that you can go, yes, this falls within jurisdiction. There's a lot of questions the tribunal has to work through, and will they be able to work through that on the information provided? It will be difficult. But I guess as an initial response, even though it's technically only binding on the other states, I think that we can't deny the implications will go broader. John, I was using land in a fairly generic sense because I didn't want to get into what's an island, what's a what's a rock, and what's a low tide elevation. So I thought referring to land was a much simpler way of cutting through all of that. So I hope you'll forgive me that I went for a low denominator in that regard. That was the extent of the choice of it, and it also fell within the maxim that we use in terms of land dominates the sea, and you have to have land to be able to talk about maritime entitlements. So I don't think it changes. The characteristics you referred doesn't change my assessment. It's still about what maritime entitlements flow from land, however you classify or categorise that land in the end. The question in relation to the obligation to negotiate and that this shouldn't be at the expense of arbitration. I think there's 2 points there. On the one hand, I was trying to make the distinction between an obligation to negotiate that exists as the form of dispute settlement that must be done, and certainly within Article 281 it refers to that length of time, you know, that once it's clear that no further settlement will be reached. So I think that's slightly separate to what you were talking about in terms of, well, have the efforts been made and they haven't been successful, and have you given the other party notice? To me, that sounds like the kind of process that should be anticipated within Article 283 in the exchange of views. So I think Article 283 kind of encapsulates the different concerns you were talking about. In relation to delimitation, and that part of that should be refraining from changing the status quo. I know this is something I need to think more about on the fly. My first reaction to it would be, just on the face of it, the obligation not to prejudice the final outcome is part of Articles 74 and 83. So if you look at 298, it talks about disputes concerning the interpretation or application of Articles 15, 74 and 83, and arguably that includes your obligation not to prejudice the final result. So that in itself would therefore fall within the exception as well. So that's my initial reaction, but I suspect it's something I need to think more about as well. Thank you.
All right, one final round of questions. I start at the back on the right-hand side.
Yeah, Professor, question to Professor Klein. You were inclined to think that in this arbitration, one doesn't really sort of survive without the concept of sovereignty, and one needs to know whom these rights belong to. But how does that approach then relate to the right of the claimant to define his claim as he wishes? I mean, you could ask from arbitration tribunal declaration of whatever on the interpretation in UNCLOS. Isn't that in the claimant's hands? And who has the right to define that also in this situation, given China is not there? Or are you rather thinking more politically of that does it really work? But legally, I find it a little bit difficult just to say like that sovereignty is necessary, but I can't recall exactly how the claim was formulated. Secondly, at least in Europe, we are quite used to, for instance, in courts in Luxembourg, that court gives interpretations on different kinds of concepts without necessarily linking them to anybody's rights in particular. So this is the system of preliminary rulings that go from domestic courts to Luxembourg, and then they come back to domestic level. Thanks.
Thank you. On this side, I know, but you've both raised questions before, so I was really looking if there is anyone else, but I'll give you the... Oh, right, so you're really beyond my... I'll give you the floor for a brief question, and then I'll move to you both also for brief questions, please. So, madam, you have the floor. Have you got a...
Yes, I do. Thank you, Madam Chair. Thank you, the organizers, and it was a very interesting conference. I have a really short question for Mr. Ugoseno. Do you think with the cooperation now, well, you talked about an ASEAN-led security, actor and also about the crystal ball. Do you think on the long term with all this cooperation, do you think there will be somewhat a ASEAN security community in the region? Thank you.
Thank you. That's a different angle altogether. That's an interesting question. Now you, madam.
Thank you. And I also have a question for His Excellency Mr. Arif. When it comes to dispute, the very principle is the states should prevent themselves open to negotiation or joint development. And those beautiful prospects cannot be found in South China Sea. And almost all the means, on the peaceful means to settle dispute in Article 33 in South China Sea has successfully failed. So I think, personally, I think the judicial mean right now in South China Sea is very necessary and important. So my question is, Indonesia as the president of ASEAN this term, should Indonesia encourage their member states to bring the dispute in South China Sea to the court? If the answer is yes, how could Indonesia do that? And if the answer is no, why not?
It is a multiple choice question, I guess. Thank you. Thank you. I now, a final question, Professor Zhu.
Thank you. Just a very short question about, because China submitted a position paper, I would like to know whether, in your view, it constitutes a preliminary objection, and to what extent the tribunal could take it into account when they decide the jurisdiction. Thank you.
Thank you very much. Can I turn to Professor Klein first?
Let me start with the last question first. Is it a preliminary objection? Well, no, it wasn't filed as an official court paper, so I don't think we can categorize it as such. It falls in the tradition of states who do not show up to courts or tribunals but still indicate their views outside the court with the expectation that those views will be taken into account. It was certainly a practice we've seen back in the nuclear tests cases back in the 1970s when France didn't show up but still communicated views. Also, I believe Iran took that approach as well in the Tehran hostages case. So to what extent is the tribunal to take account of it? You know, I'm not sure there are formal rules about how that gets taken into account, but understandably it probably will, and it's in the Philippines' interest to address those points. It's just a very difficult dynamic that's created when a country doesn't show up for the proceedings. But it will ultimately come down to the tribunal making sure that its decisions are well-founded and fact and law, and to make sure that they have jurisdiction. So, and that actually leads me to answer the first question that was directed to me in terms of what is the right of the claimant to frame their own argument. Absolutely, a claimant can frame their argument as they wish, but it falls to a court or tribunal to decide whether they have jurisdiction or not. So in terms of whether this case is truly about sovereignty or not, it's really a question of the tribunal deciding whether they have jurisdiction under Article 288. That's sort of how I see that particular point. Whether that decision is ultimately coloured by political factors, that will be for us to interpret on the outside, I suppose. But strictly speaking, no, it has to be that legal process that they would go through. So, of course, a claimant can frame their argument which will give them the best chance of winning their case, but it doesn't mean that the tribunal or court has to necessarily follow that.
Thank you, sir.
Thank you. Yes, we are actually going to have the ASEAN security community. We have pillars of security, we have pillars of economic community as well as a socio-cultural community. So it's in the part of the what the ASEAN plan under the ASEAN Charter. Now, I'm not so sure whether all is failed within the context of Article 33, because China has just acceded to the TAC in 2010, and solutions of the disputes using the TAC has not been used. I know it's complicated. Indonesia and Malaysia was not able to do that, but this is some avenue that you could consider in the future. I mean, personally, all avenue needs to be seen first, and this would be something that you could try to find out the possibility in the future. Now, I would like to also just chip a little bit on my personal thinking on the questions over there about, and also what you said about the entitlements. It's difficult to have entitlements. It's difficult to have explanation of entitlement. You don't know who owns what of the islands and rocks. And then you mentioned somehow that it relates to a landmass, the islands. For us, archipelagic state, it's irrelevant because all islands are separate. We don't have a landmass of Indonesia, one island as such, like Australia or Canada. You know, we have big islands, Borneo, which is divided by into three. We have big islands of Halmahera, of Sulawesi, of Papua, but they are different. They're standing on its own. So I think I would say theoretically it's still possible to interpret which feature is island or not, because I think this is something that has been avoided by the ICJ. So if the arbitrations wants to be brave, then they need to define what it means by human habitation, you know, the interpretation of Article 121 in the whole set of it, because that would then be useful for the other cases. I hope. Thank you.
I suspect that's a daunting prospect for the arbitrators. Well, thank you very much. Thank you to the both panelists, and thank you to raising all these questions. And with that, I think I turn to Professor Franks.
Thank you very much. Now, with only the concluding remarks standing between you and the reception, I fully realize that this is not the most envious time slot which exists. Certainly after a long day of discussions and negotiations that we had, and certainly also presentations. Nevertheless, I think it falls on the shoulders of the organizers of a conference to also hold some concluding remarks. And so what I will try to do is take up this charge and try in 3 points to close off today's meeting. First of all, I will give you a short overview of what has been discussed today. Secondly, there will be a number of acknowledgements, and finally, of course, there will be an invitation. But let's start with the most difficult part, and that is the wrap-up of this full day of presentations and discussions. Do not be afraid, I'm not going to go in every point and detail of what has been said today. I think the reception which will follow will be the better place for us, for each and every one of us, of course, to share personal opinions on whatever has been said today. Nevertheless, when going through the different panels, there are a few things which struck myself when I listened to the speakers. Let's start with fisheries. I must say that as a non-lawyer, I think for me at least this was the most interesting and eye-opening kind of presentation, because we learned a lot of issues that, and I simply quote a few of them, that sand apparently is a scarce resource in the area, that it belongs on ecosystem, and that it is not really renewable, that it takes time, a lot of time, and that we should be very careful with it, that we are fishing down the food web, that the area is radically overfished, that only trash fish remains, that there is no income from fisheries in the South China Sea anymore, and that, of course, if there is an area in dispute, we go back to the problem that we have, and that is Hardin who learned it to us. That is that you have the tragedy of the commons. You go there in an area in dispute as quick as possible and take out as much as you can. With respect to navigation, listening to Professor Zhu, I, of course, was very much struck that he said that, yes, the whole issue is one between China and the United States. And this reminded me of the question that I was at a particular moment asked at one of the last issues between the United States and China, and that was to write part of an agora that they had in the Chinese Journal of International Law, which was, of course, very challenging to try to stick out your head and your neck and try to say something sensible. But the point that I tried to raise at that time was, and Professor Cataldi also raised the issue of the innocent passage of warships. These issues are not issues which are static. It means they are moving. And as the Soviet Union changed totally position on the innocent passage of warships in the territorial sea, my concluding remarks in that agora was that China probably also, as to the future, will have different interests, and with different interests come also different positions, and that maybe simply, if we wait a little bit longer, the problem will simply disappear. Of Professor Kraska, even though he was not there, but we had a very nice reading of his paper. What struck me was apparently that the old issue, which was very hotly debated during the third United Nations Conference on the Law of the Sea, and that is the residual powers in the EEZ, is still a very touchy issue. And that means, where do we go if something has not very clearly been defined as a coastal state competence or a competence belonging rather to the freedoms of the high seas? And apparently this has not yet been totally clarified, because if we read the paper of Professor Kraska, he has a very specific point, which boils down again to the fact whether the EEZ is part of the high seas or rather of the territorial sea. And of course we have Article 59, which gives us the solution in the convention, but if you read Article 59, you will know that you have to be almost God to be able to make a sensible solution of that. And it means that it probably will be the arbiters who will have to decide in those cases. If we then turn to the regime of islands, listening to Ted, of course, I was struck by the fact that apparently you have two camps in the area for the moment. You have those who claim that the maritime features should be limited to 12 nautical miles, and you have then China apparently having a different position. And what I retained of the address of Professor Anderson David was certainly that countries have had 9 years during which everything was on the table during the negotiations of UNCLOS 3. And that if in those 9 years countries were not able to at least indicate what their interests with respect to maritime affairs were, that I think that it is a station that they simply missed, and that nowadays coming back on those issues looks indeed to be a bridge too far. Then, with respect to the last panel, if I can start with what Professor Grosvenor or Ambassador Grosvenor said, or Minister Grosvenor, you have so many different functions. It was certainly that ASEAN has done more with respect to law of the sea than we normally believe it to be the case. Maybe the South China Sea has not been, the issues in the South China Sea have not been solved, but at least a lot of work has been done with respect to the law of the sea. And then with respect to Professor Klein's paper, it was interesting for me to see that he labeled the position paper as a positive outcome out of this position of the Philippines of trying to institute proceedings against China before an arbitrational tribunal. Because this brings me back to the point that I made at the beginning of the conference today, and that is that apparently today there is this worrisome tendency that some countries do not apparently show up before arbitrations, and this is something rather new, especially with respect to arbiter, or better part, or Annex 7 arbitrations, where you have this tendency of countries not showing up. And of course, it's one thing to say that you think that the other party is totally wrong. It's a totally different thing, I think, not to show up before the tribunal. Because as we all know, as international lawyers, the competence, or la compétence de la compétence, as they say, or in German, it remains with the tribunal. And it's the adjudicature, the body which adjudicates better, that normally should be the one who makes the decision on this point. This brings me to my second point, and that is the concluding acknowledgements. I already made one in the beginning, and that was to our sponsor, which I'm willing to repeat. Thank you, Caspian Tradition, for having made this all possible. But there are certainly also others that I would like to thank at this stage. And the first one are certainly the panel chairs for having taken their time of their very often busy schedules to preside the panels and to read through the draft papers, which they all received in advance. It's an important role, and they assumed their responsibility with professionalism. Thank you all. But of course, panels, chairs would be nothing without speakers, and so certainly also the speakers are thanked for sharing their expertise with us and offering interesting perspectives on the legal challenges facing the South China Sea. I'm confident that they have left us with food for thought, as they said. The staff from the Secretariat of the Law Faculty, in particular Margot Bereboom, who is also present in this room, needs to be especially thanked. She did a tremendous job over the past weeks and has been reliable and motivated aid throughout the organization of this conference. Thank you, Margot. Where are you sitting? Okay. You're also grateful to Mieke Vinke of the Secretariat for setting up the well-designed conference website. I also would like to thank the people from the Egmont Palace, and in particular Valérie Marichal, who helped us to make sure that everything runs smoothly. And I think today nothing specifically happened which disturbed us, so thank you very much. And also our special thanks goes to Lisa O'Leary, who is our video producer today and has recorded the entire event since this morning. Thank you very much. And then finally, as a final word of thanks, I would like to thank the other members of my department, and especially Christophe Combert, but also the students who are willing to be here today and to help us out, coming in and making today a very agreeable day to all of us. So also thanks to the students and the people of my department. And this finally brings me to the third part and last part, and this is the most agreeable part for me, because this is the possibility to invite you all to a reception which will once again be held in the same room that by now you certainly know. So please be invited to our reception, and this then ends today's conference. Thank you very much.